Hello all. In the recent past, if you have remembered, two phrases have become much debatable. So what are they? Take a second and guess. So the answer is one nation, one election, that is with respect to simultaneous election. Another one is one nation, one law, that is with respect to uniform civil code. So you may guess today the point of discussion is uniform civil code. You know why it is in news. So we are going to discuss all about uniform civil code. So how it came into picture, what are the constitutional debates, why, whether so many persons have supported that it should be made as a fundamental right. Some persons have suggested that it should not be made a fundamental rights because of unity and diversity in India. Different things were proposed. Okay, so what is the timeline? Why we couldn't achieve? Okay, what are the strong points in favor of uniform civil code and what are the points against uniform civil code, and much other important cases related to uniform civil code also. Uniform civil code also we are going to look in this particular point of discussion. So stay tuned till then. So here we are going to look why it is in use. So what is a uniform civil code, the basis for uniform civil code, what are personal laws, okay, and what is the relation between personal laws and uniform civil code, how they have been evolved, so the timeline, and what is the right to freedom of religion which is getting indebatable with uniform civil code. So there are two articles, Article 44 versus Article 25 of Indian Constitution. So both are equally important. So how they have to be balanced. Then reasonable restrictions on the freedom of religion and enacting and enforcing UCC. So what are the challenges we have in front of enforcement of UCC, and what more important are fundamental rights or directive principles, okay, and also we are going to look into the judgments given by Supreme Court in various cases. Then this is related to GS2 as part of your mains in polity and governance, okay. So here the main point of discussion is uniform civil code. So why we are discussing this issue today is because Uttarakhand Assembly has been convened for a special session to discuss and to detail and to pass this uniform civil code in their assembly, okay. So you have remembered, if you have remembered, all the states in India except Goa, okay, they have their own personal laws, but uniquely Goa is one state which is having uniform civil code for all its citizens and for different religions also. So why Goa is having uniform civil code on its own means because till 1961 Goa was under Portuguese control. From 1961 onwards it came under British, okay. So because of this reason Goa is the only state in India which is having uniform civil code of its own, okay. In this context only Uttarakhand is going to be or aspiring to be the second state to implement uniform civil code. And if this concept of uniform civil code has been much debatable since many years, okay, since 1940s, even before also. So pre-independence also so many women activists have argued that there should be uniform civil code. So what is the strong contention that they want this, and all these are the things which we are going to discuss. So stay tuned. Next we are going to discuss what is uniform civil code. So what is uniform civil code? If normally in a country, okay, where it is governed by law, the basic law is the constitution, but apart from this a law is divided into two types, that is criminal law you have, another one is civil law, okay. So if you have seen in India, there is uniform criminal law. That is, whether it is in the case of IPC, CRPC, although they were replaced by BNS and all these things, but at the same time, we have same uniform law for all the communities or religious communities in India, okay. There is no difference when a Hindu commits a crime or Muslim commits a crime or a Christian commits a crime. Same offense, same punishment is awarded to the person, irrespective of the religion or region, okay. Then in this we have uniqueness. Then in terms of civil law means what? Again, a civil law is where damages can be conferred upon the person who suffered some injury or some like damages, okay, so will be awarded to this person. So what is a civil law? Civil law means which is related to personal matters, like you can say marriage, divorce, inheritance, guardianship, all these aspects, okay. So in case of this, we don't have a uniformity in India. What is the reason is because if you have observed, there is unity in diversity. It means although we are so much unified as a country or nationally integrated, but still there is prevalence of large number of religions, region, language, caste, cultures, all these ethnicities also there, okay. So in this context, if we are having different things in different domains, okay, so then it is difficult to achieve unity in one aspect, that is in terms of applying civil law, okay. In this context only there is much need, because if you have question any time, okay, so only girls have to change their surname after marriage, and even if you observe, there are different customs or different practices which are in favor of boys and which are against girls. For example, if you have observed, observed a Parsi woman, okay, if she married according to her choice another person of another community, another male of different community, then she cannot be a Parsi anytime in her future, in her future, okay. That means even she is not allowed to visit a holy fire temple also, okay. Fire is the holy thing for the Parsis, right? So but this is not applicable for a Parsi boy. So why this difference is there? And even girls are restricted in terms of alimony or in terms of inheritance. There is no equal inheritance or equal succession rights for the women, okay. So why this variation, why this gender discrimination is there when we have Article 14 which is saying right to equality? So in all this context, if you have seen, that is why the government is also it is placing Uniform Civil Code in its manifesto. Previously also it has placed, and in the forefront also it is debating this, and also it has asked the Law Commission to examine into this issue. So in this context, let us examine what is Uniform Civil Code. So Uniform Civil Code is nothing but it is a uniform law or same law that has to be applied to all the citizens irrespective of their religion in civil aspects like marriage, adoption, inheritance, divorce, etc. Okay, so that is the meaning of the Uniform Civil Code. Then, if you see what is the basis for Uniform Civil Code, is there any constitutional provision? Means yes, there is Article 44 which is forming part of Part 4, that is Directive Principles of State Policy. So directive principles are just guidelines for the state, okay, those are fundamental in governance, but that is not mandated upon the state to enforce it mandatorily, okay. And you have to remember that fundamental rights are enforceable by courts in case of any violation, but under Part 4, whatever directive principles we have, those are not enforceable in law, okay. That is the reason till now we couldn't enforce this Uniform Civil Code. So this is the basis, okay. And also if you have remembered the Article 37 and Article 36 to 51 you have in directive principles. 36 is the definition of state, and you have Article 37 which is saying that these directive principles are not enforceable or non-justiciable in nature, okay. So they are just a reminder set for the state to enforce them in as part of governance, okay. Then we'll see what is the debate between personal laws and Uniform Civil Code, and how this timeline or how the period of you can say how this debate for Uniform Civil Code has evolved over a period of time. In the British period, if you see, the British wants to control and consolidate their power over India, okay. They doesn't want India to get unified or integrated. That is why they have adopted a policy of divide and rule. And if you know, interestingly, they don't want unification of India in terms of law or any other way. That is why they have given personal laws a priority, and also they have codified personal laws. That is what happened during British period. That is, they have first framed the laws separately for Hindus and Muslims because of the policy of divide and rule. Then coming to the start of 20th century, when the demand for nationalism or independence has gained prominence, at that time so many women activists, okay, so they have raised their voice, okay, why this discrimination in terms of inheritance, succession, marriage. If you have remembered, there is a provision that even if previously before independence, even if the male have committed resorted to bigamy also, it is not a ground for divorce, okay. Only until we have Hindu Marriage Act that was enacted in 1956, till then woman is not allowed if she marries twice, okay, before if she had a living spouse, and if she go for a second marriage, then it is seen as an offense or something which is unethical or something, okay. But it is not the case with the men. So in this situation, so many women have raised their voice against these practices, and they have demanded for Uniform Civil Code, okay, in the context of equality and secularism, okay. Then what happened in 1940, okay, in 1940, when this demand for Constituent Assembly and all this have raised, okay, at that point of time, there is a National Planning Commission which was formed within the Congress, and they have first recommended that there should be a Uniform Civil Code. The idea first was proposed in this National Planning Committee of the Congress to demand that these personal laws, okay, so whether they are encroaching this concept of gender equality or whether they are strengthening. So this aspect is looked by this National Planning Committee, and they have first recommended this concept of Uniform Civil Code. Then in 1947, when we got independence, this constitutional question of whether this Uniform Civil Code has to be made a fundamental right or not is debated, okay. At that point of time, in case if it is made a fundamental right, then in case if it is violated, okay, so then you can approach the court and you can get a remedy, legal remedy in the form of writ, okay. So this was debated, and some persons, like you can see here, Munu Masani, Hansa Mehta, Rajkumari Amrit Kaur, and even our framer of Indian Constitution, Dr. B.R. Ambedkar, he also favored that Uniform Civil Code should be made as a fundamental right. Then why it couldn't be made as a fundamental right? Let's see. In 1948, in the Constituent Assembly debates, okay, so there was a debate, some section of the Constituent Assembly favored that this should not be made as a fundamental right and this should be made only as a directive principle, because in case if it is made a fundamental right, then there will be a lot of disputes in the personal laws. And you know, as we are giving, although we are a secular state, we are giving right to freedom of religion from 25 to 28. So in case if this is also made a fundamental right, then will be the large hue and cry will be there in the society. So because of this, some people have favored that this should be made part of directive principle under Part 4 of Indian Constitution. Then coming to 1950, this reformist bill was passed. This reformist bill is with respect to marriage, Hindu women, okay, so in their rights to divorce, inheritance and all, so whether they are outlawed, okay, so whether there is any requirement to bring new laws instead of personal laws, all this was debated, okay. So and you know, in 1951, Dr. Ambedkar, okay, so who have framed our Indian Constitution and who have favored that this Uniform Civil Code has to be made a fundamental right, he resigned on the context of some provisions of Hindu Code Bill which he favored were rejected by the Parliament. So what is this Hindu Code Bill? Hindu Code Bill is nothing but a set of laws which is governing marriage in Hindus. Hindu Marriage Act 1956 we have, Hindu Succession Act same 1956, Hama Act, Hindu Adoption and Maintenance Act we have 1956, Hindu Minorities and Guardianship Act, okay, this HMGA you have, all these 4 laws were passed as part of Hindu Code Bill, okay. So if you have remembered, our first Prime Minister of India, Jawaharlal Nehru, has termed this passing of Hindu Code Bill as a first step towards Uniform Civil Code, but he didn't implement that as a enforceable right, because at that point of time, if you have remembered, soon after independence, the persons or the minority persons belonging to Muslim community who have taken a choice to be part of India, if they have lost their right to maintain personal laws, again that will try to decrease the integrity values or the unity of India. That is why he favored that whenever the time reaps, okay, so whenever the time sets in, then you can implement this Uniform Civil Code. But at this point of time, soon after partition, this is not the right time to implement Uniform Civil Code, disrespecting the personal laws. That is what the opinion of Jawaharlal Nehru. Then if you see, the famous case with respect to Uniform Civil Code is 1985 Shah Bano case. Okay, so what is this case? Why this is very important? Because after 40 years of marriage, the Muslim woman Shah Bano, she was subjected to divorce. But after 40 years, according, like you know, now before Uniform Civil Code, even today also, every religious community is governed by their personal laws. That means Islamic people are governed by Shariat law. According to Shariat law, in case of a divorce, a woman is entitled to alimony only for 3 months, that is during Iddat period. Iddat period is nothing but 3 menstrual cycles whenever the person has, or the person or husband has declared his intention of declaring divorce, okay. So after declaring that intention, soon after that 3 menstrual cycles is only Iddat period. Only during that period that woman is entitled to have this right of alimony according to the Shariat law. So then after 40 years of marriage, when the husband said we wanted to separate, okay, then the woman approached that this 3 months of alimony is not sufficient for her maintenance or for her continuing her life and all. So at that point of time, Supreme Court under section 125 of CRPC said this woman, okay, so she had a right to alimony and that cannot be only limited to Iddat period, okay. So that this judgment of Supreme Court was welcomed by Muslim women, but at the same time this was protested by religious people or Muslim Orthodox people and the Muslim clerics also, okay. So they have protested. So when their protests have gained prominence, then Rajiv Gandhi government in 1986, okay, so they brought Muslim Muslim Women Protection of Rights Act, okay. So this was brought in 1986, safeguarding the Muslim or like you can say maintaining the same right of 90 days alimony only, reversing the judgment of the Supreme Court given in Shah Bano case. So with this, the demand for Uniform Civil Code has gained more prominence, okay. Then Sarla Mudgal case, this is also very famous case where the Sarla Mudgal's husband, being a Hindu, after marriage, so he wanted to go for second marriage. So without divorcing Sarla Mudgal, he have converted himself into Islam, and And you know, under Islam, a person is allowed to marry 4 women, okay, at the same time. Like he can have 4 spouses living, okay. So that is what happened when he converted himself from Hindu to Islam to have second marriage, okay. So this was also contended, and at this point of time also Justice Kuldeep Singh, okay, so he favored that there is much demand for bringing this uniform civil code, and this is very much necessary thing in the terms of national integration. At the same time, the responsibility was entrusted on the state, okay, you know, and Supreme Court has said that in this particular case, this is a matter of urgency. Then what happened in 2000, okay, in Lily Thomas versus Union of India case in 2000, you know, this case is even famous for disqualification of MPs, and this we have come across even in Rahul Gandhi case in the recent times, okay. So in this case also, Supreme Court said it could not direct the center to introduce a uniform civil code because this is not a mandatory thing. If you have read the clause of Article 44, the clause of Article 44 is saying the state shall endeavor means it will try hard to bring uniform civil code to its citizens, okay. So that means that is not a mandatory thing on the duty, but it is advisable in case in the national interest state can bring, okay. So that is why Supreme Court said we cannot direct. Then, you know, in 2016 triple talaq debate came, and at that point of time our Prime Minister have asked the 21st Law Commission at that point of time to examine this issue of uniform civil code. Then in 2017, you know, this issue of triple talaq, okay, so reached to Supreme Court, and this was declared unconstitutional. The practice of declaring triple talaq, or you can say talaq-i-ibbat, okay, this was also declared unconstitutional by the Supreme Court. Then we'll see whether this uniform civil code is violating any right to freedom of religion, yes or no, okay. So if you have seen, these are the fundamental rights, okay, and you know, these rights, okay, these two are available even to citizens of India, but Article 29 is available. These are available to both citizens and foreigners, and Article 29 is only available to the persons, even only Indian citizens, okay. You can see Article 25 is saying that individuals' fundamental right to freedom of religion is guaranteed by Indian Constitution. That can be in the way how we practice, confess, anything, okay. And you know, Article 26b is upholding the right of each religious denomination. Denomination means a group of religious people, if they're following some set of common practices and standards. They also have their fundamental right to manage its own affairs, okay, in context of religion. Then Article 29 is defining the right to conserve distinct culture, okay. This is there for the religious as well as linguistic minorities. In this context, there is a reasonable restriction. You know, our fundamental rights are not absolute, okay. When we have fundamental rights, but there are some limitations imposed also by the state or the constitution. So under Article 25, which have given us freedom of religion, there are some restrictions also placed, that is public order, health and morality. In case if any fundamental right is violating these things, then those can be like imposed with these restrictions, okay. And you know, Article 26, but they have no subjectable restrictions under Article 26. If you have seen in the Constituent Assembly, okay, if you have seen, there is a debate, as I told you, with respect to this, okay, whether this uniform civil code has to be made a fundamental right or not. On this issue, this was settled by voting, okay. And if you have remembered, in the Constituent Assembly we have different committees, and fundamental rights subcommittee was headed by Sardar Vallabhbhai Patel, and he headed this committee, and this issue of uniform civil code has to be made as a fundamental right or not is settled by voting. And what is the majority? 5:4, okay. So means five members of the Constituent Assembly committee have favored that this should not be made a fundamental right, and only 4 favored. So with this 5:4 majority, this was not made a fundamental right, but instead it was made a directive principle. Then what is a minority opinion? In the Constituent Assembly only, some persons want to give more protection to the personal laws because that is a violation of freedom of religion according to their own ideology, okay. So then Muhammad Ismail, okay, this person said to get Muslim personal law exempted from Article 44, okay. He said Muslims should be given an exemption from this uniform civil code. And then you can see B. Pokar Sahib, he said common civil code, okay. So there are demand for these even, and some people are against these organizations, some against this uniform civil code. Even some Hindu organizations are also not in favor. Then you can see Hussain Imam, he said this Muslim laws in a diverse country is not possible, okay, where there are multiple religions and multiple practices or culture. Then you can see Dr. Ambedkar, he said no government can use this provision, okay, or like under Article 44, what is the power given to the government is there, that cannot be used in case if it is forcing any personal, like any religious community to revolt against the state, okay. Then Alladi Krishnaswamy Iyer, who is also one of the member of Constituent Assembly, so he said he was in favor of Uniform Civil Code, but it would be unwise to enact Uniform Civil Code ignoring strong opposition. If there is opposition, then that is not the right time to bring in Uniform Civil Code according to this person. Then gender justice was never discussed as part of these debates, but they only thought in terms of religious aspects, okay. Then what are the things we have to look into when we have to enact or enforce this Uniform Civil Code? You can see fundamental rights are enforceable, but you can see Article 44, which is placed under directive principles, is using a phrase, state shall endeavor. Endeavor means the state shall try hard to put in this particular practice into like you can say, put this particular issue into practice, okay. So this is not mandated upon the state, but in case of other directive principles, in other articles, if you see, the words used are in particular strive, or shall in particular direct its policy, or shall be obligation of the state. So there is no obligation in terms of Article 44 text what is mentioned under Uniform Civil Code. That is why this was not made as an obligatory thing on the state. Then Article 43, if you read, that is saying that state shall endeavor by suitable legislation, but this phrase is missing in Article 44. There is no mention of that state shall endeavor by suitable legislation as in case of Article 43. So that is why the duty of the state is greater in other directives compared to Article 44. There is no much mandatoriness imposed on the state in case of Article 44. That is why till now we couldn't have a Uniform Civil Code with a common consensus, okay. But what is more important, whether fundamental rights are important or directive principles are important? Because Article 44 always gets in controversy with 25 to 28, okay. So these are fundamental rights on one hand, and you have directive principles on another hand. So which has to be upheld is the issue, okay. Then if you see, fundamental rights are paramount because they are given even by the Constitution of India directly. But Supreme Court, if you have remembered, in 1980 Minerva Mills case said that Constitution has to be established on the bedrock of fundamental rights as well as directive principles. Always harmonious construction has to be made. That is what is given in this particular case. And if you have remembered, Article 31C, which was inserted by 42nd Amendment 1976, said in case if you want to implement any directive principles of state policy for enforcement of those, whatever the law that was passed by the legislature, that cannot be said unconstitutional on the grounds that it is violating Article 14 and 19, okay. So that means to give importance to directive principles, because all the directive principles, if they are introduced by any law, because they require some legislation to back, okay. So at that point of time, every law can be challenged on the ground of Article 14 and 19, so that we cannot enforce any directive principle. So in this context, this Article 31C was placed under this fundamental rights of Indian Constitution by 42nd Amendment. Then what about this personal law? So you know, personal law is nothing but which is limited to one particular region, religion, culture, or tribe or ethnicity people, okay. So they're having their own laws. If you see different people, okay, they have different matrimonial laws, okay. And some people, if you have seen, they can marry to like in Hindu Marriage Act, okay, bigamy is a ground for divorce, but it is not the case for other religions, okay. In Islam, a person is allowed to marry 4 wives, okay. So these are the things. There are differences in this. So personal laws, if it is placed under union law, then Parliament can bring a law, okay. And have you any time questioned that whether Uttarakhand is having any power to pass a Uniform Civil Code on its own? Yes, because it is under concurrent list, okay. When a law is under, or any subject is under concurrent list, both union or the state, okay, so anyone can pass their laws within their domain, okay. That is why this bill was introduced in the Uttarakhand State Assembly for getting Uniform Civil Code. Then what are these customary laws? If you know, all Hindus are also not having same laws. For example, if you have seen recently Sapinda marriage we have discussed, okay. So Sapinda marriage is allowed and most common in southern India, but in case of northern India, in Hindus also, Sapinda marriage is considered as void marriage, okay. So they don't have this practice of getting married within common ancestor. So this is the differences we have even within Hindus. But if you see in other communities, there are different variations. For example, northern side, northeastern side, you can say Nagaland, Mizoram, all these areas, Meghalaya, all these areas, they are governed by their own customary laws, not by parliament laws and all, okay. So there are so many variations out there, and Constitution itself is protecting some states like Meghalaya, Nagaland, Mizoram and all. Okay, this is what I told you. Then if you see what is the need for uniform civil code, or what are the advantages of uniform civil code, is equal status will be given to all citizens irrespective of religion, gender, tribe, ethnicity, or anything. Okay, it will promote this gender parity, which is also a main thing that was advised by sustainable development goals. Okay, then uniform civil code would accommodate aspirations of young people who are having liberal ideology. So much of change is happening. Previously, if you have seen, girls doesn't have a right to choose life partner on their own. Okay, but now if you have seen, in the recent time, Supreme Court itself has declared that right to marry one's choice is a fundamental right under Article 21 of Indian Constitution. Then its implementation was thus supporting national integration. If you're having integrated, okay, you're having uniform laws, then it will integrate India also. That is what main aspect of uniform civil code. Then what are the challenges we have? So there are practical difficulties or there, religious and cultural diversity. Okay, so this is also there, because when India is having religious and cultural diversity, it is not that easy to bring all the persons to one table. Okay, then uniform civil code is often perceived by some persons as encroachment of religious freedom, because we have under 25 to 28 fundamental right to freedom of religion is given. Okay, so this will be an encroachment. That is what some people opine. Then it is often regarded as interference of the state in personal matters, okay, of the minorities. Then other people, if you see, the time is not right for Indian society to embrace and this uniform civil code. So these are all the hurdles in bringing uniform civil code. Then what is the way forward? So when these issues and sensitive issues are involved, so it is very much important to educate the people first. Okay, what is the need? What are the challenges we are having without this uniform civil code? So when we educate the people, the change should come from the people itself, because the law is imposed on the citizens itself, right? So if the citizens are ready and they make their mindset, okay, then that will be easy for implementing that particular law. In the same way, so a good environment should be made, okay, must be built by the government and the civil society organizations as well as religious organizations to have this uniform civil code. Okay, so this is the way forward. Then the theme based previous year question, you can see, a legislation that confers on the executive or administrative authority an unguided or uncontrolled discretionary power in the matter of application of law violates which one of the following articles of Indian Constitution, whether it is Article 14, 28, 32 or 44. So answer in the comment section. Then prelims question for practice, you can see, who can introduce a bill in the parliament to implement uniform civil code? As I told you, personal laws under concurrent list, so it can be tabled both in parliament or in state legislature. So who can introduce this bill? Whether a member of Rajya Sabha or Lok Sabha or union minister or all the above. Answer in the comment section. Then you can see, discuss the possible factors that inhibit India from enacting its citizens a uniform civil code as provided in the directive principles of state policy. This was a question asked in 2015 itself, okay, because in 2014 the present government has placed this uniform civil code as part of its manifesto. Okay, so as we have come to the end of the discussion today, we have discussed about uniform civil code, what is the issue, why this issue has come to the forefront, what is the timeline of this debate of uniform civil code, what are the pros and cons, and what are the advantages, and what is the way forward we have seen, along with some important Supreme Court judgments. So this is all with respect to uniform civil code. Thank you.